Hi, this is Tom Mazzoni talking to you deep from our bunker, deep below Seacrest Wardle's Troy office. I removed my mask. I hope you can hear me. I hope you're all safe and well. So we're going to be discussing the current state of the law on open and obvious hazards. I do this for clients, so if you're new to Michigan and you want a more detailed analysis of the rule and the various fact patterns that come into play, you can obtain our premises liability handbook at no charge, just for the asking. In it, you'll find a chapter devoted solely to this rule. For the majority of listeners, I'm going to assume you have a basic grasp of the rule and the key areas in which it applies, particularly in slip and fall cases, darkness issues, and landlord and tenant cases. In general, the good news is that there have been few significant developments in the last year in the Court of Appeals. In trial courts, judges are adhering to the key elements of the rule and are generally dismissing these cases on a motion for summary disposition. It is still fairly rare that a case ends up being sent to a jury on a fact dispute. By and large, the Court of Appeals and the Michigan Supreme Court have shown no appetite to chip away at the basic proposition that in Michigan, a person on someone else's property is solely responsible for his or her own conduct, and that accidents are largely the result of a failure of those persons to pay attention to the things that are there to be seen. In those situations, the court will not impose liability on a property owner or a property manager, even though those people and entities owe a general duty of care to business invitees, or in other words, to people that they've invited onto their property. Even so, there is no liability in the case of an open and obvious hazard. The courts in Michigan have also consistently ruled that people are expected to be able to do simple things in their own daily life and do those things without blaming others for injuries that occur in the process. Courts have been particularly tough on people who are injured while, for example, walking up or down a flight of stairs, even stairs that fail to satisfy the design requirements of one building code or another. As we know, the question for the trial court on a dispositive motion in this area is this: would an average user with ordinary intelligence have been able to discover the danger and to avoid it upon casual inspection? This is called an objective standard. It has nothing to do with whether the particular plaintiff saw the hazard. They all say they didn't or they couldn't, but that's beside the point. The law looks to whether a reasonably careful person would have seen it and avoided it. The provision requiring a casual inspection is extremely helpful to defendants. At first blush, something that appears on a property might be covered or it might be hidden from view. For illustration, ice on a pond. The ice might be very thin, and the plaintiff who decides he's going to take a walk out onto the lake or the pond may not see how thin the ice is. If that casual inspection requirement was not there, a landlord or property owner could more easily be sued by a plaintiff claiming that the property owner created a hazard that the plaintiff did not see or could not have appreciated. But once you add this upon casual inspection requirement, those kinds of cases just fade away and honestly are never brought. So in 2019, there's a good example of this casual inspection requirement. It's called the case of Ardvinson versus Polly's Food Service. It was decided in December 2019. The plaintiff fell in a puddle of water in a grocery store. She fell near a cooler that sold bags of ice. She described the puddle as being about 6 to 8 feet in length. Importantly, the plaintiff testified that she wasn't watching the floor, or looking down at the floor as she was walking. She also admitted that the lighting in the store was adequate. A store employee, by contrast, and obvious, and dismissed the case, saying that a casual inspection by the plaintiff would have avoided the accident. Therefore, that plaintiff had no claim because there was no duty on the part of the store owner to avoid an open and obvious hazard. The next important consideration in evaluating your cases is that the question of whether this rule, this open and obvious hazard rule, applies to the facts of the case is for the judge to decide and not the jury in the typical fact pattern. The open and obvious hazard rule is an issue of legal duty. It is the first of 4 elements in a negligence case of duty, breach of duty, causation, and damages. Issues of duty are generally for the trial court to decide unless there's a significant factual issue needing a jury's consideration. Let me give you an example in a different context. So the question may be in a case, is a bartender required to find a ride home for a drunken customer? Well, that question is not for a jury to decide. The question is one for a judge to decide based on past legal precedent. It's a question of legal duty, not factual decision. And parenthetically, the answer to that question is no. A bartender doesn't have to find a ride home for a drunken person. The open and obvious hazard rule applies regardless of age or mental condition. Remember, it's applied against the standard of what a reasonable person would do or not do, not the particular plaintiff. So the particular plaintiff's characteristics, be it blindness, be it youth, be it old age, are irrelevant to a consideration of what a reasonable person would see or not see, how they would behave or not behave when confronted with a particular hazard. Lastly, in general, we've spoken about the class of persons to whom the rule applies and to whom it does not apply. So we all know by this point, because you listen to these seminars every year, they do not apply, the rule does not apply to vendors. For example, snow removal companies. So in a case where you have a slip and fall, let's say at a mall, in a parking lot, the mall owner, the mall property manager will have available to it the open and obvious hazard defense, but the snow removal contractor hired to keep the lot free and clear of ice and snow does not have that defense available to it. Similarly, municipalities sued under a statutory obligation to keep sidewalks free and clear of hazards cannot raise the open and obvious hazard rule. At least they couldn't until the legislature amended the statute, I think in 2017 or 18, that now statutorily the open and obvious rule is now applicable to sidewalk cases in Michigan. And then finally, any non-owner possessor of the property cannot assert the defense. So for example, it's an undecided question is, for example, let's say a real estate agent is holding an open house in your house on a Sunday afternoon. Well, and let's say that a person falls, let's say it happens in the winter and a person falls on ice and snow on the driveway. Is the real estate agent and his employer responsible for those injuries? And the answer depends on the extent to which the real estate agent had possession and control of the property. All right, so that's not an easy question to answer, but it's the class of persons generally, if you're not an owner or a possessor of property, you don't get to assert the defense. So this is my favorite photograph. I use this all the time. And it gives you a perfect example of the open and obvious hazard rule in its application in the most extreme setting. So without question, that is a hazardous condition. That porch has been knocked apart. I know the owner, it's my partner's porch, and he took this photograph because if you look carefully at the door, you'll see that someone, despite the yellow tape, despite the broken bricks, managed to put a flyer on the door. And what he told me is that it's coupons for pizzas. And so if that delivery person, if that person distributing those flyers fell on that hazard, well then of course they're not going to succeed on a claim of negligence because that condition without question is open and obvious. Well, what if the person fell at night and the plaintiff testified that he or she could not see that broken concrete because it was too dark? Well, in Michigan, there's a whole line of cases that say that darkness in and of itself is a condition of the land that's obvious. So it should have been clear to the delivery person that if he or she could not see where they were walking, and yet they chose to proceed anyway in the face of total darkness, that they did so at their own risk. So darkness doesn't help plaintiffs generally in their claims for negligence in a premises liability case. So next, well, what if the house was a rental? Does that change the analysis in any way? In Michigan, a person who's injured on property that occurs in a residential real estate setting can bring a cause of action under two different theories. One, they can claim a simple negligence, or two, they can claim that the accident violated the Michigan landlord-tenant statute. So here it is. This is the key provision of the statute. And it says in every lease or license of residential premises, the lessor or licensor covenants, promises, that the premises and all common areas are fit for the use intended by the parties. That's the key phrase, fit for the use intended by the parties. You'll note in reading this statute that the word negligence doesn't even appear in it. It says nothing about available legal defenses. And it doesn't mention a word about the open and obvious hazard rule. Through case law, however, we know that in general, the statute is treated like a species of negligence, like a Cocker Spaniel is to a bulldog, kind of the same, but kind of different. In truth, the appellate courts have treated this statute, in general, very favorably to landlords, even though it's now clear that the open and obvious hazard defense does not apply when responding to claims made under the Landlord-Tenant Act. In 2019, the Court of Appeals added a little bit of clarity to the issues involved in landlord and tenant cases. We're going to talk about them now. There's a couple of decisions worth mentioning from last year. But before we get to them, you have to understand the basic concept that's at play here. And the key case is called Allison versus AEW Capital, decided by the Michigan Supreme Court in 2008. In that case, the plaintiff was a tenant who fell in a residential parking lot that had 2 inches of snow. The plaintiff was on her way on foot to her car when she fell. The plaintiff claimed that the landlord failed in its statutory duty to keep the parking lot fit for the use intended. And the claim was, well, the intended use of the parking lot is to get my car, and I have to get to my car on foot, and if you don't keep the parking lot clear of ice and snow, then you've failed your statutory duty to maintain the premises in its intended condition. The Supreme Court dismissed that case, and that's been the basis for many dismissals thereafter, because the first question that the Supreme Court asked was, what is the primary purpose of a parking lot? They answered the question this way: the primary purpose of a parking lot is to house cars. Everything else is secondary. In this case, cars were nicely housed in that parking lot. And consequently, the court said merely walking to and from the car, that's not an essential purpose of the design of the parking lot. And as long as the parking lot is housing cars adequately, then the plaintiff's case fails. Now, it didn't say that case will always fail. What it did was it looked to that secondary purpose. Okay, we understand you have to walk to your car. But in doing so, the court said that doesn't mean that every bit of snow has to be removed from a parking lot. Instead, it looked to the evidence that was presented in the case, and that evidence was there were footprints, many footprints and tracks in the snow, suggesting that cars were going in and out of the parking lot and that people were walking to and from their cars. And the plaintiff in this case was the only one who complained of having fallen. Taking all of those facts into account, the court said that this parking lot satisfied its intended purpose under the Landlord-Tenant Act, and the case failed. So in 2019, the court looked to different fact patterns. In Schuster versus River Oak Gardens, the plaintiff fell on a sidewalk, not the parking lot. And she fell on a sidewalk that was in her apartment complex while she was on her way to retrieve her mail. And in her deposition, she testified that everything that morning was covered with ice. In this case, the court asked the question, as in Allison, what is the primary purpose of the place where the plaintiff fell? And that is, what is the primary purpose of a sidewalk? The court answered it by saying that the primary purpose is for pedestrian travel. Therefore, where there was evidence of a complete covering of ice, there was at least a question of fact in the mind of the appellate court as to whether or not the landlord failed to maintain the premises in a condition fit for its intended use. Consequently, the Court of Appeals sent the case back to the trial court for trial on that issue of whether or not the landlord in that case had maintained the premises in a condition intended by the parties. In a second opinion in 2019 is the case of York versus Berger Realty. So this is an extreme example, not a photograph from the Berger case, but I want you to assume that the plaintiff in this case was intending to walk to one of those cars. However, in the Berger Realty case, the plaintiff testified that she had walked off the sidewalk and into a handicap access area in the parking lot. She said that the access area was for walking. The defendant claimed that the access area for handicapped persons was in the parking lot, and consequently the defense raised the issue, well, what's the primary purpose of a parking lot? It's to house cars. The plaintiff said, but I'm in an area that allowed no cars. I was in a pedestrian handicap area in the parking lot. Surprisingly, the Court of Appeals sided with the defense and dismissed the case. The court said that walking in a parking lot is secondary to its primary purpose, which is to park cars. The court said it doesn't matter that a particular area of the parking lot does not allow cars in it. The question is simply, what's the purpose of a parking lot? It's to house cars. Where were you? Oh, you were in the parking lot? You lose. In another decision, the court talked about a case involving winter weather conditions, and that's a frequent pattern of cases that we continue to see. And the case arises by virtue of the plaintiff's claim that the place where he or she fell had an isolated piece of ice, often called black ice by them, and by virtue of that claim, they say, well, I couldn't see the spot where I fell, or the ice in the spot where I fell, because black ice by its nature is invisible. And if it's invisible, it can't be open and obvious, certainly not obvious. However, the line of cases that's been consistently held, including a decision in 2019, was that, well, yes, even though you may not see the particular piece of ice on which you fell, if there are general winter weather conditions going on in the area at the time, then you, as an experienced, Michigan resident who knows about the hazards of Michigan winters, know that you can encounter ice and snow at any time, anywhere during the winter months. And so the evidence looks to, well, is there snow flurries? Is the temperature below freezing? Is there snow piled in other areas? Is there ice in other areas? And in the one decision in 2019 called Diaz, D-E-A-S, versus Hartman and Tyner, the case was dismissed for that very reason, that even though the plaintiff couldn't see the particular area or the ice where she fell, and there was no evidence to suggest she could have, but there was evidence to suggest that there was general winter weather conditions going on, and the Court of Appeals, consistent with prior decisions, dismissed the case. In the last decision, called Kelly versus Grahowski, the plaintiff was at a friend's house, and in the house was a swinging door. It's the only photo I could find of a swinging door. But think of this door in the interior of someone's house, and the plaintiff leaned against it, and in leaning against the swinging door, fell down a flight of stairs to the basement and was seriously injured. Of course, the plaintiff got an expert, and the expert testified that the design and placement of those swinging doors at the top of basement stairs was both hazardous and in violation of BOCA code. Nonetheless, this is one of those cases where the Court of Appeals said, in life, you should be able to do simple things. And more importantly, you should know not to do simple things. And they said swinging doors are something that you just shouldn't lean on. And the condition of the swingingness of the doors was obvious, even though the plaintiff didn't know that what was behind the doors was basement stairs. Nonetheless, the court said that swinging doors is an open and obvious hazard. So this just reinforces, again, prior case law that's been consistent, that requires people to be able to do simple, common things on their own, and when they do them poorly, they're responsible for their own injuries. All right, that's it. Thank you all for listening. If you have any questions, you can be sure to call me. Call Mark Masters. You have our number, and stay safe out there.